There we go. Check, 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 check. One, two. Can you hear me okay, Joe?
I can. Can you hear me?
Yes, loud and clear. Thank you so much.
Hello.
So I got to let all the panelists
I
know.
heard a hello. Was that a
Hello,
Nick?
that's Nicholas Rogers.
Yay, Nick. What's up, man?
How you doing?
Got
Doing
Ryan.
all right. How's your Sunday going, Nick?
It's going all right. Getting stuff together. Um, Adulting this weekend, financial planning.
That
Yeah,
never ends, by the way.
I know. I've noticed.
Oh, oh, ask me what I did this weekend.
What's up?
Went to college with my son to check out Delaware.
Oh, beautiful. Oh, that's
So
fun.
from where you're at to where I'm at, start saving
That's a long
now.
goal. Oh, that is a part of what's happening right now.
Get
Working on it.
You cannot have enough 529s.
Oh, yes.
Joe knows that.
So how's he liking it? This is his first time seeing the campus?
Yeah, you know what? I think he's still processing. It's the first time ever on a college campus. And as we drove up, the first thing's like, it's so big. I'm like, it's more like a medium-sized campus. But to
Yeah.
him, he's used to that small pond. Now it's
You said
giant buildings.
You said you took him up to Delaware, right?
Yeah, Delaware University.
Yeah.
The fighting was it the blue hens? Like it always cracks me. It always cracks me up what the mascots are.
Yeah. There's a school near us called School of Mines, which is an engineering school.
He applied to that actually. Yeah,
Yeah. Their mascot,
yeah.
the ore diggers. Like, what could be more terrifying than? I mean, that's up there with Panthers and Jaguars for their overall scariness.
Well, yeah, you're in Colorado. You're used to those. We city folk are used to that.
It's just so funny that they decide there's sort of really sad looking soccer field, and then on one whole third of the panel around the field there's the ore diggers, and I'm like, man, that's a word you do not want to accidentally say. You want to enunciate perfectly when you're saying that word, because there's like and saying that word the wrong way. Like, God,
Try saying that after a few keggers, right?
you want to be very, very careful. You better enunciate the crap out of that word.
Yeah. Nick, where did you go?
We've got four of you. We'll wait and hang out for a little bit. Nicholas and Ryan, I think this is your first time being on one of my calls. Jason's an old hat. He's been, organizing these things for pretty regularly for, I would say, the better part of a year, right? I mean, more than that, probably 15 months now. Since June of 24, we've been hosting these meetings very regularly. There's a library of these that are going together that I'm putting on a page that I'll share with you guys. I think you probably did you already share the US Gov right?
Joe, by the way, I wouldn't put this one that we're having on the webpage just because there are people who are contract managers signed up on our case that would report to Techno Arts. So if you don't mind, this one should not,
Yeah, we don't listen. I don't have to put any up. I've been pretty careful. What I've been trying to do is go through and sanitize them.
Gotcha.
So that there's nothing that there's no indication. I haven't been perfect about that. There's probably an AI software out there that would do it for me, that would edit it. I'm waiting for that to come out, right? But just go through and sanitize, remove any names, and take
I'd say this one altogether, don't put up. Because Nick is still working there. Ryan's still working there. Scott and I have gotten the boots. They don't want our ilk kind.
Yeah, by the way, is Scott joining? You said Scott might not be able to join us because of medical reasons.
Scott, are you on this?
He's
I
not.
talked to him earlier. Let me shoot him a quick message and see if he's having trouble. Hold on. You can keep on talking to the guys. I'll shoot him a quick.
Yeah, I mean, I'll give you guys, what I'll do is just kind of let you know what's going on. I'll give you guys a quick background on me and what the case is about, and then we'll spend some time today talking about how you guys might fit in into the case. Part of how you guys fit into the case is the part that we've pried open since the case started, which is kind of cool and interesting in a completely way. But So, and I'm guessing that Jason's told you guys one thing about the case. It is so we filed this case. I'll just go back to the origin story. So, we filed this case in Jason's name alone, but in the name of Jason and all similarly situated contractors against the federal government for the purpose of recovering overtime pay primarily, but other benefits as well. But probably the most quantifiable piece is the overtime pay that nobody was paid. And the contract under VOA with these folks was really draconian. I mean, they weren't allowed to submit invoices for overtime. They weren't allowed to misrepresent themselves, quote unquote, misrepresent themselves as employees. They had these folks in a box where they could basically just come in, bill purely by the hour, and yet they had to be on call 24/7. So we filed this.
Sound familiar?
We filed this claim this complaint in federal court in January of 21. It eventually, within the next 6 months, it moved to the Court of Federal Claims, and then the government's argument. So a lot of people asked me earlier this morning, because I had another meeting this morning, like, do we have any defenses for the government arguing that you weren't misclassified, that you were supposed to be classified as 1099s? And my response to that, truthful responses to that, is that the government has not even signaled that they have not raised that argument in 4 years. They have not raised the argument that these folks should be 1099s. The argument they raised instead, where they chose to plant a flag instead, was they can't be employees of the federal government because they weren't appointed as such, and appointment is required. That was their entire argument.
I think you guys are W-2s, right?
Yes.
Okay.
Yes.
Yeah, with Technarts.
You guys are W-2s of Technarts, correct?
Right.
Yeah, but just to give a sense of that, like we signed a contract, and recently there's been these arguments about PTO, and one term that came up that I told Jason, I think the other guys probably heard, was like, we are classified as salaried hourly. So it gets into this weird level of like what you just said, like we have to be on call, yet us reporting overtime hours is this kind of weird thing. And then also, getting time off, lunches, breaks, all this, like it's all very tenuous. So I'll leave it there just to say
no, you're
odd classifications.
So this is one of those things that, like, employers, and not just your employer, lots of employers, even internally in my firm, right? I've had to educate my own payroll people. Like, we have folks that are salaried, but they're non-exempt, meaning they're still qualified for overtime. They're still eligible for overtime. There's a common misunderstanding that if you're salaried, then by extension, you're not eligible for overtime. That is only true if you fit into the very narrow exceptions to the overtime rule. And there's an executive exception and an administrative exception. And almost no one fits into either exception.
Interesting.
So, but what you got, so what I'm betting is happening where you guys are, is that the employer is trying to have their cake and eat it too. So they are requiring you to clock in and out, but they are also deprived. They're saying you're not eligible for overtime. Does that sound right?
Yes, what we get is comp time, like a one-to-one comp time. And something I've shared with these guys recently was, when I started there, it wasn't clearly defined. It's just track your hours. And then there became a snafu kind of recently about, who owes PTO hours, tracking for that. And only recently, like after a year and a half for myself, it's like, oh, we're supposed to be submitting these into our Harvest timesheet app as supplemental hours. And I'm like, that's only been told to me in the past probably 2 months. So like a year plus went by of, again, just not knowing how the overtime system works, other than they basically said, you don't get overtime, but never clarified the mechanisms. And kind of going back to the hourly salary, like, we've never seen real contracts. It's always this kind of amorphous, like there are contracts in the background, but we never quite know what the details or stipulations are.
So let me ask you a question. So Ryan, was that you, Nick, or Nicholas, or was that you, Ryan? Speaking of?
Ryan here.
Right. Okay. So, and I was just diverting my eyes over to the right here for a minute but here's, let me just ask you a question. Just, this is law school 101 stuff, right? If you work an hour of overtime, what do you believe that you're entitled to?
I mean, you're asking me under normal conditions, usually time and a half.
That's right.
Yeah.
You're absolutely right. So if instead I give you 1-for-1 comp time, right? Let's assume for the sake of this argument that that is legal, which it is not, but let's assume for the sake of this argument, should you get 1 hour for every hour you work overtime?
At least. And actually, I should get my time and a half.
There you go. Right.
And this goes.
For comp time to even work, I mean, and it doesn't. I'll just tell you, spoiler alert, it doesn't work. You're not allowed to do comp time in lieu of overtime. You're not allowed to do that. But a lot of employers try to do that. But let me tell you what at a minimum it would have to be to even be defensible at all. It would have to, and no one does this. The government's not doing it. They do just like you're describing, 1-for-1 comp time. Well, if you work 41 hours, you get an extra hour off. That's crap. That's just giving you 50% less than what you're due, right? At a minimum, on top of the fact that
Oh,
it's
yeah.
money, and it's supposed, because then when so it should have been at least time and a half. So you should have got 1.5 hours off for every hour you worked overtime. But think about how else that is wrong, right? You accumulate PTO, right? Don't you accumulate PTO? It accrues as a percentage of your hours worked.
Believe so. It's actually, it's always a little bit of a question how it works there.
Yeah, no, that's right. But my point is, like in most places where you work, you get, like in my office, you get 13 days of, we call it paid, personal time off or paid vacation. Let's call it vacation time for the sake of this comment, because there's two buckets, right? There's vacation pay and there's sick time.
Yeah.
Right.
Tell me about
So in our office, which I stole this from my time working in the federal government. So, for your initial time there, it graduates just like it does in the federal government in my office. So as a W-2 federal employee, for the first 5 years you're there, 3 years you're there, I think. And it's in my hand. It's memorialized in my handbook, which it's supposed to be also, right? There should be somewhere that you can turn to a resource that says, these are my rights. This is what I'm allowed to do. And it sounds like in your space, that has not happened. It's not memorialized anywhere. And if it's not memorialized anywhere, then what happens is it defaults back to the statute, which is the FLSA, which means that for every hour that you work, you're entitled to an hour and a half. You're entitled to 1.5 of your pay. And this is why it's so important. And the accrual of your time off pursuant to the formula that the company is using. Right. So think about how that's the way they're doing it. It's goofy. They're giving you part of what you would have already gotten anyway, which is the accrual of time off. Plus, they're giving you less than 1.50% of your pay for the time that you work, which should have been realized in your pay, and you should have been taxed on it. And earn FICA tax. I mean, there's all these things that you're not getting. You're not getting your FICA tax that way. You're not getting. I mean, it's just wrong on several levels.
Yeah.
So it's not. They can't do this, and it's a cost saving mechanism that somebody convinced them that they're allowed to do, and they're not. Like time saving. It's a money saving mechanism.
Hey Nick, just really quick. You guys have been sent on a lot of E&G stuff recently. And are they paying you for your overtime, or
No, there's no overtime there. You're getting extra hours, and that's about it. So it's
you're getting extra
essentially the
work but
same
not extra
process.
pay?
Yeah,
Good.
because you're getting paid for that travel, and you went through it, and it's the bare minimum of what they feel they need to do for comping you for it.
How is this not something that we can protest and throw against them and be like, hey, who can we report this to, or what can we do, Joe, other than our case that could maybe stick a monkey in the wrench or a wrench with the monkey, whatever way it goes?
So what? Let me make sure I understand your question. Your question is, how do we make it stop now? Is that the question?
How do we bring attention? There's got to be some sort of systems in place besides us inside the government that we could say report this to and be like, hey, they're working these people past what they're supposed to be. They're breaking the laws with them. They're making them travel and do all this stuff, which is, as David Long would say, tantamount to slavery. What is there any other elements we can bring in here to help these guys or no?
Yeah, 100%. So I was just waiting for you to finish your question. So the answer is yes. You have conflated a few things. There's a
Okay.
couple of things going on. So part of what you described, like unreimbursed travel, that's flatly illegal in almost every state in the union, period. Right. So, I mean, and I mean, like, not just first of all, when you're traveling, you should be on the clock for all of it.
Yes.
Okay. That period. And they don't, they don't like to do that. They like to say, well, if you travel to Virginia and you're in Virginia working, then what they have to, as a minimum, what they have to do is have to pay you per diem for the time that you're gone.
Are they paying you guys the right per diem? Because when I did it, they were paying me the wrong per diem and they were only giving me like $48 a day. And they said, well, on this site, it says that.
That's about what's happening. Yeah.
Jesus Christ.
I haven't traveled yet. I haven't had any serious travel other than kind of local for DC, but I've basically been warned because, yeah, you have to pay up front. There's no company card. There's all these questions about reimbursement and kind of
Yeah,
to
and
this
I've
point,
had
like,
this question with them as well, constantly about there being a company card, them paying because we're paying out of pocket for everything and getting
yeah,
hopefully reimbursed in time.
yeah,
It's
And
hundreds of dollars.
you're probably not getting reimbursed the full amount plus the interest that is paid on things either, are you?
Absolutely.
God
right.
damn, they suck so
And
bad.
and same thing, like Nick, I don't. You can speak for yourself, but I can mention that like Sean Chadwick, for example, he did a couple, shoots on whatever locations, and like he's made comments like, man, if we'd be making overtime, I would have made bank on this, and it's turned into this game for all of us now. Like people come in early to make up their PTO hours. Like I know DZ was talking about the other day, like he was showing up 2 hours early to make up whatever time. Like all of us there are in this fucking deficit. And like you
Yeah.
said, it feels very indentured in a way of like, again,
Yeah.
the tracking was not explained till later. And, to segue into something that I talked to Jason about earlier, I'm like, this year, my ulcerative colitis came to a 4. I got, whatever disability designation, and still trying to get them to honor like telework and take it seriously has been just aggravating.
Oh, Joe, real quick. They're ignoring his ADA, by the way, that he turned into them. Technoarts.
Yes.
So this is what I was getting at, guys. So the answer to Jason's earlier question is that yes, there is recourse for everything you're talking about. And unfortunately, it's sometimes difficult to consolidate that recourse. So a very easy place to start with the overtime question is the Department of Labor. And the last thing your boss wants is the department, your specific complaint is they're not paying, it's overtime. It's called overtime theft, wage theft. It's a wage theft claim for your overtime payment, right? And you can bring this DOL complaint. And the good news is it kind of puts a moat around you also, because the very second they attempt to fire you, that's retaliation under the FLSA. And now your damages calculations goes forward, which is something we're talking about separately. So you have the DOL phone call is free, right? And you can pick the call up and it can go after your guys. And now what I will tell you is that the DOL is an enforcement agency. They will, create a fine. They'll go through this administrative process. It won't be a lawsuit. We have this lawsuit that's currently filed that I'm bringing, and I've met one of the doors I mentioned at the beginning that we pried open was it started with just independent contractors, people like Jason who were working directly for the government as 1099s. The government was issuing the 1099s directly to the person, what I call the employee, the putative employee. Then there's this second category of clients or plaintiffs that I brought into this thing that was just like you guys, folks who worked, and they came in by way of Social Security, for example. They were working for government prime contractors, but they were, because of the prime contract, look, I'm not trying to be techniarts apologist. I'm not. But what I'll tell you is, you can judge them all you want, right? But what I'll tell you is probably true. is that they have a contract with the United States government that they more or less was like ones that many contractors sign, take it or leave it type of contract, in which it makes no room for overtime, doesn't authorize overtime. Now, here's the difficult spot that TechniArts is in, and those like him, and those Cardmazis and the other, and Jason's heard me talk about these folks, and I've defended some of these folks as it relates to like terminations for convenience or termination for default, because their employees just like, look, I'm not going to continue doing this if I don't get paid overtime. Is that once the TechniArts of the world find you guys and place them in the federal government, their control over what your day-to-day activities essentially evaporates. You're now working for, in your case, the DOJ or VOA or USPS or whoever.
Oh, absolutely.
But shouldn't they have like a statement of work that they needed to sign of what they're supposed to be doing for the DOJ with TechniArts?
So the answer is yes. It is normally extremely vague, opaque. Like you're going to be we need, so it usually comes out in the form of a request for proposals, right? So RFP comes out and it says, we need 50 bodies to do these things. The list of these things, these deliverables are usually, not, they're sort of abstract or vague, like, anyway, like we need them to provide video services. Now that's set to the unlearned reader, that sounds specific enough, right? But to you guys who know what you're doing in this space, like you're like, well, God, that means any number of things, right?
Oh yeah.
Am I repairing video equipment? Like what exactly am I doing? So the statement of work that you would envision, Jason, that if you were doing work for me, you and I would have a very express and detailed statement of work of what I was expecting by way of deliverables. I want edited content. I want this. I want that. You know what I'm right? But more, even if that were all in the RFP, and it is not, there is normally a disclaimer. It comes out, the contract comes out as what's called a firm fixed price contract. So the contractor, TechniArts of the world. Again, I mean, look, I want to preface this again by saying I am not being TechniArts apologist. I'm giving context as to how they get there, right? So the contract comes out as a very disfavored type of contract vehicle. What it should be what's called a time and materials contract, right? So what it should look like in Joe Whitcomb's University Government contract, it should look like this. TechniArts says, here are the hourly rates that you get for the, a video person. And guys, I don't know anything about what I'm talking about, so forgive me when I say these words, right? But so videographer level 1 is worth X number of dollars. We're gonna, and those qualifications look like this. They've been 3 to 5 years of doing this, and yada yada yada. And then videographer 2 is something more qualified. Videographer 3 is more qualified, and they make more money accordingly, right? And the government tells them, like the government usually tells them, like it should look like an RFP. We need people to be able to do these types of jobs, and we need you to send us a proposal for what you're going to pay those people. That's what a time and materials contract. So the Jason Lambros of the world, they're going to come to you for, I'm just using the contract, they're going to come to you for $40 an hour, right? And then
Never.
let's assume that happened, right? And I'm just using a round number because it's easily divisible by 2, right? So and you can easily do 1.5 line, right? So they said Jason Lambros of the world, they're worth $40 an hour. Now, government, you're in charge of how much you work them. If you work them 37 hours, you pay them 37 hours. If you work them 45 hours, you pay them 40 for the first 40 and then 60 for the next 5, right? That's what it should look. That's called a time and materials contract. And it was always at the government's disposal to do that. But instead, they did a firm fixed price contract, and they tell the contractor, bid this as if, and this is in the RFP, I promise, it's in every RFP I've ever read on this front, bid this contract as if your people are going to work 1,887 hours a year. And you're thinking, why, Joe, why is it 1,880 hours a year instead of 2,080 hours a year, which is what 40 hours times 52 looks like? It's because they're taking out, the 11 holidays, the 11 federal holidays, PTO, the sick time, and just build.
They're making it so you can't basically get overtime, right?
That's right. That's exactly what it is. It's bid this as if your people are working. Now you just heard me say you don't get vacation pay. It's on the employer to pay vacation pay out of that bid. So what does the employer have to do? All right, well, look, if I'm going to pay Jason or Nicholas or Ryan $40 an hour, then I better bid this thing at $60 an hour, because remember, I got to pay FICA tax out of that. I got to, I also have, if I pay Jason 40, I'm supposed to pay him, health and welfare, which is like $4.80 an hour to pay for health insurance, right? And at 170, and the average, work month is 173 hours, right? So if you have, and I know I'm doing a lot of math here, guys, but if you work 173 hours and you get $4.80 an hour, then you have about $830 a month to throw at Benny's, and that's where that money is supposed to go to. And you don't have to pay the person. The employer does not have to pay Jason, Nick, or Ryan, Nicholas, or Ryan the $4.80, but they have to provide that money either in cash or in benefits, cash, benefits that are equivalent to that, right? So that's what it's supposed to look like. And if let's say Jason's health insurance comes in at $500, then the other $330 would go into like a 401k matching, something like that. You know what I mean? Somehow or another that the employer is supposed to do that. And so the employer has to figure out, on a firm fixed price contract model, the employer has to figure out how much to bid. If I'm going to pay Jason 40 and I'm going to anticipate that there's going to be some PTO, some sick time, and I want to be able to, I have to pay him the health and welfare, and so I better bid this, and I only get to bid 1,887 hours, so I better bid this thing at $75 an hour so that I have enough room to do it, right? The Techniarts of the world almost always, because remember, it's a competitive bid. So whoever bids the least wins. So whoever takes the sharpest knife to their bid wins. So the awardee in these cases always ends up, by virtue of the way the government selection process goes, always ends up being the one who bid the least, the one who took the sharpest knife to their bid, and almost always, invariably, is the one who underbid as it relates to providing for overtime, vacation pay, adequate benefits, all the other stuff. Does that make sense?
Sounds about right.
And then also baked into all of that, right? The other restricting vein in all of this is that everything you guys do falls under what's called the Services Contract Act, SCA, or which is part and parcel with the Davis-Bacon Act, which relates only to construction workers, which means you guys, I bet you've heard this term. There's a prevailing wage table, right? That somebody follows along and says, all right, videographer 1 is supposed to make at least $37.38 an hour plus the $4.80. So that's the low. Even if they could get one of you to agree to a payment of $25 an hour, they'd be in violation of that statute if they paid that money. See where I'm going? So that is why, this is how the government sets the Techniarts of the world up for failure. And so again, right. I'm not saying that like these guys are excused, they have to do what they have to do, right? But it's kind of a lose-lose. If it weren't Techniarts, it would have been somebody else. So my argument to the court, which the court seems to be, Jason was there, like the one thing that Summers seemed to be buying, is that the government has constructively created this process, but they've engaged in a constructive violation of the Fair Labor Standards Act because I can promise you 100 times out of 100 times, this bidding method will result in what you guys are going through every single time.
Yeah.
Joe, let me ask a quick question if you don't mind me.
Sure.
All right, so if we were to contact, and I would do this for the guys without mentioning their name. I'll do this because I'm already fired. I don't care. But if I call the Department of Labor and be like, hey, I need to report Techniarts for what they're doing. Most of us have been injured in the hospital, going to have surgery. Who in the Department of Labor do I call to do that? And what would the recourse be? And if I needed to have these guys write a statement, if they felt comfortable with that.
I'm just not trying to cut you off, but I know exactly where your head is, because you and I have talked about this a lot. So a lot of that will depend on say Nicholas and Ryan's or Scott's relationship with Technics. If for the sake of this conversation, they are garden variety W-2 employees of Technics, right? That, and this is where your case was different. If you, and you got to forgive me because you asked a question, so that opens the door for me to revealing a little bit of personal information on you. But I will say this: if you're an independent contractor and you don't qualify for workers' compensation, even although you can sue through workers' compensation for misclassification, the way we talked about before, right?
Mhm.
But if you are a W-2 employee, and that's how a lot of misclassification cases come up, like, hey, you don't qualify for workers' comp because you were a W-2, you weren't a W-2, and then the response to that is, yeah, I'm a 1099 because you classified me that way, and you shouldn't have. And the same rules apply. So workers' compensation is the apparatus that is supposed to cover these injuries and have compensation built into it. There's a schedule, like if you hurt your back and your ability to work is diminished by 10%, there's a table and it pays you that money, period. And it comes out of an insurance pool, which is great for you so it's great for you. It's not a very flattering table. In other words, the table is the table and it's statutorily controlled, right? But there are catch-alls, right? So let's say a back impairment, and I'm just using this for round numbers. Let's say a back injury, follow your finger out on the table, and the back injury is worth $40,000, right? Period. But there's another subcategory or an adjacent category of like persistent pain. And maybe that is left to the finder of fact to determine how much, then the finder of fact, like the judge, the ALJ, or the insurance company, or all the actors together work together and say, all right, well, Jason's ability or Scott's ability to continue full-time competitive employment is diminished by X percent, and that is worth X, maybe that's worth $100,000 or 12 or 120 or 500,000. You can have somebody dies on the job. Workers' compensation is supposed to cover that, and it pays up to it. And the reason that if you employ people in every state and union I'm aware of, I'm not aware of any exceptions, you are required to carry workers' compensation insurance, which pays out pursuant to the person's what they make. So somebody who makes $15 an hour is going to get less workers' comp than somebody who makes $40 an hour. If that makes sense. So a workers' comp, if you're a W-2 employee, a workers' compensation claim is the first thing to do. And all you're supposed to have to do is alert your employer that you were injured on the job, the end.
What if you have a persistent, and Ryan, let me know if you feel comfortable talking about any illnesses here in this situation is specific to you. But what if you have a persistent illness that is exacerbated by the work, the job, and
It's called an aggravation.
right?
And an aggravation is compensable.
Could you elaborate a little bit more, or?
Well, that doesn't say at all. An aggravation is compensable. I thought that would be self-explanatory. No, if you have an existing injury, pre-existing injury or illness, and it is aggravated by the work that you are doing on that particular job, then workers' compensation is required to compensate for that.
So he should be able to talk to Techno Arts, say he has this persistent condition, and they should accommodate that, or they should.
It's a separate issue. Now you're talking about an ADA claim, so that looks like we're having.
Maybe I should have said ADA, because I know that he's actually turned in an ADA to these guys, and
ADA is a lock, right? So let me explain how that works a little more granular level. Let's say you have a persistent illness, persistent condition that limits your ability to lift more than 12 pounds. Can't lift more than 12 pounds, can't lift anything overhead, can't stand for more than 15 or 20 minutes at a time, right? Now let's say that the job that you're supposed to be doing requires you to handle a 50-pound, I'm going back to my youth, it requires you to handle a 60-pound jackhammer breaking up sidewalk, right? Then with the employer, you clearly can't do that job, right, anymore, period, under those limitations that the doctor gave you. What the employer is required to do under the ADA is to find another job within the company that you can do if one exists. Right?
What if one doesn't exist? Then do they have the right to let you go, or?
They do have the right to let you go if your accommodation basically doesn't allow you to perform the work anymore, right? Let's say you're in a customer facing an agency or a company that all it does is face clients, right? You take client calls all day long, right? And you have and I'm not being facetious for me because this is real study, it's real case. And you have an uncontrolled, unmanageable case of Tourette's. Every time you get on the phone, curse people out on the phone, right?
Why didn't I think of that move when I was working there?
There's a straight face argument that like you can't do the job. Now that doesn't leave. Now one of you guys all hear me. Like that doesn't leave the person on the street, right? So what that means is like you may have to go apply. Like if the universe of works is completely eliminated for you, then you have Social Security as recourse. You should, by the way, just a free PSA, right? Like if your employer offers, short-term disability or long-term disability, like my company pays for and this might be something your employer pays for, and they pay for long-term disability insurance, which means if you're out of work for 6 months, and it may allow you to pay for, or it might pay for short-term disability insurance. Always investigate whether that happens. Look on your paycheck, see if there's any deductions for it. Ask your employer, hey, is long-term that should be in your employee handbook. That's one of those things that should be disclosed.
What employee handbook? They've never given us anything.
I know this is one of the problems with.
Sorry, Nick. Sorry.
No, it's 100%. You guys are 100% right. It is completely wrong for you to work for a company and not even know, like you could just quit the company and not know that, oh, by the way, I've got, or you just like go in, you skulk into work and like, hey, I can't do this job anymore. My back hurts too much. I can't do it. Well, if the employer doesn't tell you, oh, by the way, we pay for long-term disability coverage, right? You're eligible for that if you're out of work for 6 months. You can do that, or you pay for you pay for short-term disability. Usually, that only requires you to be injured or out of work. Like most short-term disability policies, pay on the first day of injury or the 7th day of illness. And they pay like 66 2/3% of your pay. In Colorado, there's a state law that says we got to pay for the first, I don't know, there's a certain amount of time we've got to pay that we also have short-term and long-term disability. But
that's a good point, Ryan. You should look up what they have for DC. Nick, you should look up what they have for Maryland. I cut you off earlier too, Nick. I know you got a question. Sorry, Joe, but I know I cut him off.
I don't remember what question I had.
It was back during the handbook question.
We're good. He's explaining everything well.
Yeah, I mean, I want you guys to understand, and this is one of the things that's good to have like somebody like me at the ready, is that there's always a lane to go, right? There's always something to the idea is to make sure that we don't end up with, like, that's why it's a fairly reliable assumption that if someone is like literally living on the street and homeless, right? Their biggest problem is probably a lack of community. There's a lack of people that they're informing them like, oh, look, there's this recourse you can seek. You've got undiagnosed schizoaffective disorder. And if you had the diagnosis and sought the care, you'd get at least SSI, right? Something that would pay a stipend and get you into HUD housing and, be able to get you off the street. There really isn't I won't say excuse. There isn't a reason a person literally has to be on the street anymore. There's probably a resource out there, but we're not talking about people like you guys aren't talking about people being on the street. We're talking about if you have a garden variety injury at work, workers' compensation. Like Jason, we've talked about this before, and I'm bringing it back home for you. But you have an actionable workers' comp claim. The fact that they told you, well, you're not employed, you don't work for us. That's just one of the legal arguments that has to be overcome. We're bringing it by way of a slip and fall, but we'll probably enlist a workers' compensation.
That's awesome.
In Maryland to co-counsel with us to show that you were now. We can look at where we've been battling this around. Kelly may have said it's like your case is a little more convoluted because you were a Maryland resident working for a DC employer.
Actually, they're in Maryland, Techno Arts. DC.
The actual right, but again, we're using that punitive employer, right?
Oh, right. We're going for Ashley. You can say it in front of them.
Yep. Yeah, the DOJ, and then you were doing the work. That the injury, actually, I think you told me happened in Florida, right?
Yep.
That's as convoluted as it gets, right? You're a Maryland resident working for a Maryland company that actually contracts you out to a DC organization, and you're on a plane working in Florida. So that's just goofy as hell. So that's like, It's really more complicated for the defendant because we've got like 4 places we could choose to sue the defendant. And they've got to find out reasons we shouldn't. So that's all secondary. Like,
What's the one that's going to be the biggest pain in the ass to Ashley McGowan?
what's that again?
Well,
What's the one that's going to be the biggest? Sorry, what's the one that's going to be the biggest pain in the ass to Ashley McGowan?
Well, the one, so she is her biggest problem would probably be the slipping. Workers' compensation is supposed to be basically a lane. You get in it, you get paid, I really, I mean, when we start talking about this in February, like that's the path that I wanted you to go right away, because the default is the workers' compensation insurance pays for your injuries. And then we basically paper the file and worry about compensation down the line after we get to what's called maximum medical improvement. Once we get to a place where we're like, all right, you're as good as it's going to get for you physically.
I thought I wasn't able to since I was a 1099.
That's what I'm trying to tell you.
Oh, sorry.
We're at 1099 by virtue of the misclassification.
Gotcha. Got it.
See what I'm saying? Now they'll say, well, no, Jason has to be. And my answer is, I don't care. It doesn't matter that Jason has to be. Jason has to be CEO. You're going to give him that title. It doesn't matter what your employee wants. If the law says he's an employee, he's an employee. And you were, for all intents and purposes, Jason, you were an employee of Technology at all times. The fact that you had a contractual relationship with them is not relevant to me.
Mm-hmm.
Can I jump in for a minute on one of my things? And since I have both these guys here, I know I've talked to both of them about it. And Joe, I want to bring it to you because this gets kind of a blurry line back to the ADA thing and some stuff that we've experienced where, so this year I had a pretty serious bout of ulcerative colitis come to the fore. I think there's some pretty clear lines, and I've shown Nick and Scott and Jason the emails saying up front of like, hey, I'm concerned about these duties. And then once my colitis really kicked in, I did everything of getting the ADA form, being very conversant with them.
Yep.
But I feel like there's lines drawn there. But and this is, having Jason and Nick here to kind of confirm that I'm not misreading this, but I mean, like, one of the things they said for me was like, oh, you'd be able to have, telework, things that I was supposed to be provided, like my own bathroom. And so often I felt obliged to come in because we had this big project that both Nick and Jason and everyone's aware of with this catalog Veritone thing, which again, like there are absolutely stresses from that. There were days where, again, Scott was there firsthand for a meeting that just basically crippled me. The next day I took off, and then the day after that, my colitis started to appear. So, I mean, it seemed a pretty clear line. But, some of the concerns is like, now that I'm here at the end of the year and, we've been talking about PTO, overtime and stuff like that, I kind of got hit with these whammies of like my colitis kicked in. We won't get into all the various other aspects of my health, but also like I had a pretty serious issue with a landlord that both these guys are aware of that, all my PTO has been eaten up trying to solve problems, and there's been no rest. And it really surprises me, like, if there's never an offer of short or long-term disability, and I felt like I never had an area to rest. I felt that I was obliged to be on the job. And I mean, I know that these guys saw it, and again, I'm just trying to do a good job. But it was one of those moments, like, now that I'm here at the end of the year and theoretically in better places, I'm still just like, are they going to basically say like, oh, you now owe us 3 or 4 days from last year for all the PTO stuff? Because they never explained any of the mechanisms of reporting the shit. And we even said this at the beginning of the conversation, like, fuck 1-to-1. It should have been time and a half. This should have been clear. But I'm just looking at my accommodations for the colitis.
And so, right. So I want to, you've got a lot of different questions and a lot of different lanes in there. So I'm going to break them up into pieces, right?
Yeah.
As it relates to the ADA, your responsibility begins and ends with the letter from your doctor that says these are the reasonable accommodations, right? Then they are required to come up with a plan. Now let's say your reasonable accommodations are, again, we'll just use this as an extreme example. The accommodations are, you have to be able to work from home 100% of the time, right? It is an acceptable response from the employer. They have to do a real and full-throated and authentic and genuine analysis to say, like, no, it's not possible to do this job 100% remote, right? But let's say they come up and say, well, this could be done 75% remote. They have to offer, if it's realistically done with 75% remote, then they have to offer you that accommodation, right? Now, let's say they put that, it sounds like they put that accommodation in writing, correct? That's what it sounds, or something like that. They put a reasonable accommodation in writing, and then the word that won't come to mind right away, it's called a constructive breach of that accommodation. So they said, yeah, you can do this, but then they created conditions that made actually doing it impossible. Does that sound right?
That sounds about right.
So that means
And these guys were here to kind of see it in action. So, I mean,
right.
if anyone feels that wasn't it.
What that means is they haven't actually, they put an accommodation in writing, but they haven't actually followed through. So you aren't actually being accommodated. Now, what you can expect when we go, we sue them or whatever, and they say, well, look, we put this accommodation right, but you didn't let him. You then constructively violated it by creating projects that he was a part of that wouldn't allow him to do the things that he needed to do at home or have, he didn't, you said he had his own bathroom, but then and I don't know if any of these facts are true, but just bear with me. He said he had his own bathroom, but then you did all of these jobs that were outdoors where he didn't have access, or in a remote building where he didn't have access to this private bathroom, right? Or whatever, you see what I'm going, like, in other words, if the accommodation wasn't realistically actionable, then they haven't complied with their requirements under the ADA. Now, a defense to an ADA claim is, either we did it or it wasn't possible to do because, we're only required to make reasonable accommodations, right? We don't have to build, we don't have to build him a separate building, right? We don't have to, we don't have to do the extraordinary. We have to do what's reasonable, right? But,
Right.
they put what they believe were reasonable accommodations in place. And then it sounds like what you told me is that they then didn't
do shit.
they didn't follow through on any of it, right? Is that what I'm
No,
hearing you say?
I mean, the
Or they
big
didn't
rub for me, like one of the clearest indicators was like at the end of the year when we were getting into these PTO snafus and arguing stuff. I'm like, well, I had this note saying that I should have been teleworking, and there were days where it's like you're marking me off. I was like, well, again, like I'm literally sick with the doctor's note from the ADA. Like, why am I haggling with you about sickness? And just another thing that was really appalling, and I showed the guys these emails where it's like, at a certain point with them, I tried to question, the PTO deficit. And I said, well, like, I had 20 hours. I tracked this. I can go find them and justify it. I wish I would have recorded it, but like the response I got was like, well, we'll honor 16. And I was like, well, why can't you honor all? Like, why is this even a negotiation? Like, I did the work. Like, that was just infuriating to me after, again, showing up with the colitis, trying to make sure this fucking catalog project moved forward. Like, it's very aggravating. So there, I'll
Did you
stop
call
going ahead.
I heard the word baritone in there. Was I hearing that correctly?
Yeah, it's a project and a company that we were obliged to help, and shit, Nick has had a lot of laughs with me about, like, we've had to pamper them and make this thing float for this very varsity or junior varsity group of people, where it's like literally we were told from Ashley, like, hey, don't put too much obligation on these guys, or I forget exactly the phrasing, but it was one of those like, don't stress the client. Was that it, guys? Like something to the nature of like, wow, these,
Don't task the vendor
yeah,
was what
like
she
what
was saying.
it, we've gone to the point where we've questioned internally, like, is this some kind of like payola scheme, or is there something nefarious here? Because like what they're providing is just so hackneyed and long running of a joke, and it insults a lot of our professional experience of like, this is a canard. So
Well, so
that's a whole nother
that's
thing, but I
how
mean, it's just
I want to attack your problem. So on the one front, we've already addressed this. Like this one-to-one PTO time
yeah,
is garbage. That's indefensible. They will get their ass handed to them on that front. Period. Okay. And since you guys have all sworn pretty freely, I'm going to be my normal self and not edit my normal person.
Yes, please.
So then the other thing is the other. So we've got the PTO, like that's a dumbass place for them to plant their flag. They're going to lose there. The 88 thing, like they have vulnerabilities there. And then to the extent that any of your injuries or illnesses were exacerbated or compounded by virtue of the work that you're doing, whether the work, because it's not like they have to give you some extraordinary thing like that to tell you to lift by yourself, because this is something that came up with, I think, with Jason and Scott, which was that, a bunch of stuff they're describing are just textbook 2-person, 3-person lifts, right? Or machine lifts. Like some of the stuff that these guys are doing, I think if we really run this back to OSHA, should not be done without the assistance of like a hand lift, or I mean, you guys have all seen like the hand dollies or the hand driven forklifts that where you get to put it under something, jack it up, and then move
Yeah.
it that way. Like
Well,
all of
well,
this.
just as a secondhand note, Joe, like they've had so many discussions about how much gear they need to take on the road and these kind of negotiations of like, oh, we got to take all this gear. Well, how many people? And just seeing them try to like do the minimum with dangerously less has just been evident there.
Yeah, and what I'm trying to, where I'm going with this, guys, is like it's the violations are honestly just kind of legion, right? And we got to basically pick our poison, because it's, I mean, like, we have to be careful when we tell the story that it doesn't sound like fantasy, right? Like you're going to work for Corella DeVille every day, right? Like, I mean, it's like
It's worse.
it's garden variety stuff, right? But it's not something like the DOL would get into this stuff. It sounds like you got DOL as far as federal agencies go. You got DOL and OSHA right out of the gate. You got workers' compensation claims that you should be filing as it relates to your injuries that were sustained on or aggravated by your employment.
So we filed that with Department of Labor. We try to file that with Techna Arts.
Which one of those things I just said are you talking about?
You said file for like our injuries. We do that for like long-term, short-term, whatever, or what's going on.
Right. So that, yeah, again, it conflicts. So I want to make sure we're talking about different sides of the same coin. For your treatment, right? This is going to the doctors and not having to pay your co-pays, deductibles, that's all workers' compensation. These are the injuries. The treatment for your injuries is workers' compensation. That's right. And I will send this video. I won't send it to anyone else, but I'll send this video to you guys so that you'll have it. You can refer to it. Okay. But so you have, I'll just reply all to Jason's email and I'll have this if that's okay with everybody. Then the other piece, then you have so that will get you both the treatment and the compensation. I said treatment, that starts with treatment. Then once you're at like maximum medical improvement, which means you're as good as you're going to get. Doesn't mean you're cured or healed, just means you're as good as you're going to get. Then we go to workers' compensation insurance to compensate you for basically for your loss of productivity, right? Your ability, the amount, the way the statute is, most statutes are designed, is to compensate you for your lack of market, to say it as politely as possible, your lack of market, your decrease in marketability. Does that make sense? Like you're less marketable as an employee because you have these injuries or these impairments that were worsened or caused by your employer. And then the next piece is you have your workers' compensation for your purpose of getting you paid for these injuries. And then you've got DOL for your overtime. I mean, we can sue them under the FLSA, no problem. Like we already are actually. They're already in the suit by way of Jason. We just add you guys to the suit and we just wait to get paid on the back end. And it's a good way to go because.
So these guys need to sign up and let you know that you need to sue them on their behalf, or do they? How does that work?
All I do is just add them to an opt-in. It's all the stuff we're talking about overtime, Jason. All that stuff is back pay, and then we'll do separate Form 95s. Well, we don't need a Form 95 for the state-based claims. We would just need to file a separate suit as against Technics. But we're going to sue. Remember, I told you we're going to sue the federal government under the Federal Tort Claims Act in federal courts all over the country. That doesn't mean they have to be the only defendant.
Okay.
It could be U.S. The case could be. I'm just using these. It could be Jason, Nick, and Ryan versus United States of America and Technics.
What do we need to do to protect ourselves in that case of our names getting put on documents?
So here's what I've said this a lot on a lot of different meetings. I want you guys to hear me say this. You will not be a named plaintiff. You will be on a document that is submitted in the filing that somebody has to have a Pacer account to find in the first place. You're not going to show up in a Google search, right? I scan these things in so they don't even OCR, right? So it's not searchable at all. They don't
know what OCR means.
OCR. Okay, when you know when you PDF.
Optical character recognition.
I got you. We're there.
Thank you guys.
I love you guys. That's
That was
awesome.
gonna shock me there for a minute. Yeah, it doesn't, it's not gonna be, I'm not OCRing this stuff. It gets submitted to the court. It looks like a JPEG, right? And then, so that means it's not mineable. They would have to literally go in, know which case they were going into, right? They would have to go to, there's like 50, 60 different filings. None of them are labeled, they're labeled opt-ins, but they don't have anybody's name in the filing. So they would have to click through all these opt-ins just to find your name. And then if they did anything shady, like, I mean, reduce your work by an hour, you know, it's retaliation. I mean, it's textbook retaliation, and involving the Department of Labor as it relates to like technical. So the Department of Labor will be slower to enforce, as Jason has seen, I'm sure, will be slower to enforce as against a federal agency as they will be against a private entity. Against Techniarts, they'll go crazy on Techniarts. They'll be bashful and standoffish about going against another federal agency, but they'll go gangbusters against Techniarts.
Do it, guys. Do it.
They will absolutely go batshit on those guys and watch them like a hawk.
I'm already down for it.
And let me tell you something.
I think these guys are saying sign them up right now.
Yeah. So here's all I got. You know what this looks like, right, Jason? You guys got my. I'm going to drop my form in the chat here. Okay. And then you guys just put it on here.
Can you send it to our emails, please?
I can do a reply all. If, like,
Yeah.
you want,
Yes.
on there. Yep. Easily done. And since you hurt these guys' feelings saying they didn't know what OCR was, I'll just go ahead and also drop this. And this is what you're looking for when it hits your inbox. Okay. If you don't click it now, you form. Nope, that's not the right form. Lambro.
If it comes to me, guys, and you guys don't see it like by
Oh,
tonight,
yeah,
let me know, and then I'll
I'll-
forward it to
I'm
you.
going to reply all,
good.
Jason, same one that sent this link out. Okay. I'll send a reply all to the same place I sent this link. And this is the link you guys are looking for. Okay, I'm going to drop this in the chat. Everyone, boom. All right. If you guys click that, I'll send it to you in an email. It'll tell it's a form that'll take you, a minute to complete. All right. And it'll go into my inbox, and you guys will end up, if you want, you can end up, but if there's a box to check that says, hey, I just want to join, you'll get an engagement letter here within the next day or so. In fact, I've even enlisted my family's involved in this case. Now, like my wife and teen kids are in the business of like pushing forms out now. They earn a little. My kids are earning, better than they can make on an allowance. So, they're on my payroll at work, and I follow all the rules. They're part-time they're part-time employees. They work for me, so they do whatever I tell them. And none of them work anywhere close to overtime. So anyway, that'll come out. I'll send the email out as soon as you and I get off the call. This recording will come back. I will send that to you guys, and then if you have any questions, once I get you guys engaged. The good news is, once I get you guys engaged, you'll have a portal in my software. It's called Clio. It'll come from Clio, CLIO, and then you will have a direct line of communication with me, by way of text, by way of email. And I always tell people, like, use the Clio chat mechanism. Because if you guys send, as Jason knows, man, sending stuff to my email it's like, I get like 300 emails a day. It's a vortex.
Right.
The odds of me losing it there are good. You send it straight to the portal. I literally cannot, it's dummy proof. I can't miss it. There's a big red dot on the left-hand side of my screen that won't go away until I read it.
Are you both seeing that, the HTTPS shared forms, HS forms
Yeah.
in the window? Okay. Nick, can you
Yeah,
see
I
that?
got it right here.
I'll
Yeah.
send it
right
out
on.
to you guys as well. Like I said, I'll send it out to you guys here in an email too. So just in case it's not super legible. Whatever, I'll just send that to you guys in an email. So that's okay. If you guys have any other questions, we've been on for about an hour. If you guys don't have any other questions, Well, we can hop off. I'll send this email, this video, the Zoom video will come back to me here shortly. I'll send that out to you guys so you can review it. Zoom creates transcripts now. I can send you guys a transcript. I don't know why you would want to read that. It seems painful. But you can, you can review it. And then again, I won't put this one because you guys are sensitive to it, but I will tell you to answer the question about, one, they can't retaliate against you. Two, we're going to bring the DOL on this thing and put a bright light on Techniarch so they don't think about retaliating. I want you guys to hear me say one last thing I didn't tell you. When you involve the Department of Labor, the real teeth in that involvement is that these types of violations have what's called personal liability. Tell me if that means anything to you guys.
I'm not quite sure.
So what normally when you form a company or an LLC, right, that is created for the purpose of protecting you from personal liability, right? Like you sue the LLC to pursue the company. When you have FLSA, SCA violations, these type of labor violations, they create personal liability, meaning the owner of Techniarch, the individual owners of Techniarch can be personally liable for the damages that you guys incur. That is terrifying for every proprietor, every merchant. That's why they will not risk.
I love it.
Your damages don't, by the way, just so you know, your damages don't look like the overtime they didn't pay you. It looks like the overtime they didn't pay you times 2, plus any consequential damages related to you not getting paid, plus my time. That can be a company. So it is a big, big stick.
Hey, Joe, real quick, I just want to make sure it's okay for these guys, if they have questions in the future, to contact you personally. Is that correct?
That's right. Yeah. I mean, that's one if they become my client, obviously, right? If they opt into this case, then you are my client just like any other.
They are in this case right now. I mean, I'm not sure about Ryan, but I know Nick is.
If Nick is in the case, then he should have a portal from me that if he's on an engagement letter, he's a client. He can obviously, right? If you are in an engagement,
Wait, Ryan, you're in this too. Yeah, you are.
I think so. There was getting signed up earlier in the year, and
can you confirm real quick to make sure? That'd be great. Thanks, man.
yeah.
Cleo, log in. It's gonna be like 60 seconds to get logged in this time. Gotta get through all my 2-factor stuff.
Not a problem. Guys, while he's doing that, how are you feeling with all this? And it's been a long sort of journey to where we are. We're not even close to it yet, but trying to kind of get more information. I know that I feel more informed and in control, even when I was working there, just being able to bounce questions off Joe and have a better understanding what the laws and the rules were after talking to Chris's bullshit and TechnoArt's crap. I highly suggest Joe is a great resource, and he is always there for me, and I'm sure and I know he'll always be there for you.
Well, I feel much better. It feels good to know that I have an area to go if I have any actual legal questions. Knowing what the law is
Right.
kind of sets things straight for me.
Right.
So Nicholas Rogers, you're not this Nicholas Rogers. I've got a Nicholas Rogers in here as founder and head chief executive officer of Brewer at.
Yeah, that is not me.
So let me
Not
go
with
out.
that attitude.
Let me do this. Let me go here. Let me look you up in HubSpot. Let me see if you're one of those folks that is waiting on a engagement letter.
Double check my list too. I know he's on my list.
Well, yeah.
Well, I know I've received stuff from you and signed an engagement letter before.
Let me make sure that's true. I've got it here. RDGER, yes.
Have you been getting emails? Nick? Like of the webinars sent to you?
I haven't received them as of late, but I have received them before.
Okay.
And I have been, if that's a good sign.
So Ryan, Bill, Evans, so let me look you up by email, Nick, and you're not coming up here. Let me look you up by email. All right.
By the way, I got a text from Scott. He obviously isn't going to be able to join. I think there's a issue right now at home that he needs to take care of.
I bet.
All
Well, and
right.
again, just for his sake, like we'll share this with him, but I'm sure he, even just to get this secondhand, he'll be appreciative, and I'm sure if he could weigh in, he'd love to.
Yeah, I hope so. We'll talk about it off headsets. Not that actually, it's you guys. He said that his wife was screaming at him and that he might not be able to join because his wife's very upset with him right now. So it's one of those moments.
Oh, wow.
Yeah.
It's crazy, but okay.
I've been on that. I've been on the receiving end of that stuff. I'm not going to judge. Yeah,
Yeah.
anybody who's been married for longer than 15 minutes knows what that feels like. Nick, I just plugged your email, nicholas.c.rogers@gmail, into my case
I'm
client
sorry. Try ncrogers88 @gmail because I've been getting from two different emails for you guys.
NC Rogers 88.
88.
All right. That is, my system has that confused. Do you know a Gus Sudol by any chance?
No.
Whatever reason, my system has completely screwed this up. Is your last four of your phone 8365?
Yes.
Okay. For reasons that do not make any sense, this thing is confused. Right there's the case. It's 203. You're in the system 203, 205, 317. Nick Rogers. So Nicholas didn't come up. Nick Rogers did. Your name is right. Your number is right. I don't have your address, which I will want to have. But let me look at your documents. You got a signed engagement letter. You've been in this case since July of 24. You're there. I'm going to send you a portal right now while I've got you on the phone. That just is I call it my bat signal. Right? Use this to get on, it's like, I'm not kidding around. It's like, you shoot me communication on this thing, and I'll shoot you a text to the system also. And then you can reach me like literally at an obnoxious level. So Nick, here is the portal. You are signed up. So this is really smart software, but apparently it's not smart enough to pick up the connection between Nick and Nicholas. All right. So you're all signed up and have been since July. And while I'm at it, let me just look for PILL. Ryan, you are in here with a doc. Signed engagement letter since March.
Do you mind checking up Scott Crawford?
Yeah, and Ryan, you've got a portal from me too that I sent to you in July, I think, of this year. I'll put it at the top of your inbox.
Awesome. Thank you.
Here is the portal, Joe, and then you can communicate with me there. And let me do what I said I was going to do. What I didn't do with
Don't forget to check Scott Crawford if you don't mind.
I'm going to do it for sure. Ryan, here's a text from me. Yeah, this doesn't go to my phone; it goes straight to my system. So you text on it. Just save that 833 number, Ryan, that you just got from me, and that is a way to communicate straight into my system.
Thanks, sir.
I called it Skynet, by the way.
I just got your email.
Nick, this is Joe. All right, do the same thing for Nick. All right, now let's look up Scott's last name.
Crawford.
C-R-A-W-F-O-R-D. I'm 900% certain I've got Scott in here. Like, that's one of
Okay.
those things that for whatever reason sticks out from me. Let's look at the documents on him. Documents, yep, signed as of, again, July of 24. He was on one of those initial like email blasts that remember it was like right after Doug left and we signed up like 30 people in the next, I don't know, 10 or 15 days.
They're laughing because they remember Doug.
Yeah, one of my managing attorneys in the firm had a coup and left and took one of my paralegals and a bunch of clients on July 1st, and we started a fight that's still going on since then. Anyway, the upshot to that entire episode is we signed on Lambro went from Jason and like 6 or 7 other people to we ended up with 80 by August, and now we're sitting at about 250. I want to get the momentum back up because we were signing up, about 10 a week for a while, and I think that's not a bad number. That's like 500 a year. I want to get back to that 10 a week number. I think we can do it if we just get the word out, capitalize on these WhatsApps. I've been using spending money on Facebook, and I want to use the Facebook platform if that's the right one. Once Jason does some.
I was gonna say I would like to, when we start shooting some of this stuff, shoot some stuff for you that we can put on the WhatsApp page with the group, the PSEs, and the other stuff.
I found just side note, I found a bunch of that beat footage of these interviews. I sent them over to you last night to look at. I think there's some usable content there as it relates to my website generally, but I also like it as a sort of a format of what we could do to create some good usable content. But I'm going to follow your lead on that.
Send me also the scripts that you had from GP Chat so I can kind of go over the content so I can stay true to it.
Yep, I've got it. Well, and also like don't feel committed to that. Like
I'm going off script, absolutely.
Yeah, that's 100%. Like I have no professional. I always tell any creators that I talk to, like, when it comes to creative, I have zero professional jealousy at all because I'm not. I know what my strengths are, and it's not in the creative universe. All you have to do is look at my wall hangings. That's clear. It's covered with freaking admissions to every court in the country, but there's nothing pretty up there. So, anyway, guys,
you do what you do, and I do what I do.
Yeah, that's our bread and butter, Joe. We got you.
Everybody here is signed up. You don't need to sign up don't need to do anything more. You guys have portals and links to my connections. And like Jason's right about something. I mean, I'm stupid responsive. You send me something, you're going to get a response back from me. And again,
except at 4 o'clock in the morning because his wife won't like that, which I learned the hard way. 2-hour difference
behind him. So I'm up at 4 in the morning, but I'm up at 4 in the morning Mountain Time, which is his 6 in the morning. So anyway, shoot that stuff to me, guys. Use those channels to connect with me. If anytime you need to, I just got something back from one of you, I think. That's how fast it works. It goes straight to my portals. And yep, I got a Nick received and yeah, we do a lot of communicating through this portal. I love the crap out of it. All right, guys, I'll send you this Zoom when it comes up. I'm getting ready to get in the car and drive up to Breckenridge. I'm meeting with my CEO peer group called Vistage up in Breckenridge for the next couple of days. But fortunately, I got all packed before we got on the call. So I'll talk to you guys. I'll talk to you guys shortly, and it was good. Hopefully, I answered a bunch of your questions. If I didn't, any come, just shoot me more questions. All right.
Thank you, Joe. Appreciate it.
Talk soon.
Good talking to you, fellas. Take it easy.
All right.